Today, I'm going to talk about some things that I have learned practicing criminal law during this COVID era. I know COVID has really thrown a monkey wrench in many of our lives, in all aspects of our lives, and especially in our careers as well. There's been a lot of changes, but I want people to have an open mind about these changes and really embrace some of the changes for the better, because I think this is going to be the future of criminal defense, as well as I think we should embrace some of the technology that's being incorporated in a lot of the courtrooms. So that being said, I'm going to show you all the agenda that I'm gonna kind of talk about. There's like a top 10. So we're going to talk about jail visits, communicating with prosecutors, communicating with the court, docket and pretrial appearances, hearings via Zoom, hearings live, grand jury packets, bench trials, jury trials, and last but not least, pleas and sentences. So, and at the end, I will reserve, 10, 15 minutes at the end, and I'm happy to answer any and all of y'all's questions. So that being said, by the way, I've also emailed a zip file that has some very handy materials in there that you should all receive at the end. And yes, that should help you with your practices or soon to be practices. And by the way, congratulations to any and all of those of you who passed the Texas bar today. Big accomplishment. And I remember mine like it was yesterday, May 2nd of 2013, best news of my life. So that being said, let's get into it. So jail visits in Harris County. The jail is not really allowing lawyers to go in person and visit their clients. I think under some rare and extreme circumstances, you can ask to do that. You might need a court order in order to do that, but not to fear, because jail visits have never been easier. So for Harris County, there's two ways you can visit your client in jail. And so number one, if they're housed in JA07, so JA07 is the 701 San Jacinto housing block. And if they're housed in JA07, the way you would visit your client is via Securus. So there is this third-party company called Securus, and their website is securus.com. And if you go on there and you have to register as a lawyer, you scan and submit your driver's license and your bar card, and you will have an attorney account. Once you have an attorney account, you can schedule and visit your client using Securus for free. That's great, because Securus has been available and around for a while, but until recently, you had to pay to use Securus. But because of coronavirus and COVID-19 restrictions, we can now use Securus to visit our clients for free. So this is one of the things that I alluded to, is I hope Securus stays free for a long time to come, because sometimes it's just really difficult to get down to the jail after court, but it's super easy to do a Securus visit from the comfort of your home, your office, or the airport if you're traveling, wherever you may be. In order to do Securus visits, I'm going to give you a practice tip. You need to download the app either on your phone, iPhone, Android, or your iPad or something like that. It is not a web-based program that you can use, or at least I haven't been able to get it to work web-based. But the app works great. So the Securus app, it's free. You download it, you log in, and you connect your headphones to it. I highly recommend using your headphones. The app even recommends using headphones. And you can visit with your client, and it's awesome. And the best part about it is, once you're done with the visit, you will get an email confirming the visit. So if you do court-appointed work and you're tracking time, boom, it sends you an email at the end summarizing your visit, the time, the date, how long, the duration of the visit. So it makes it really, really easy and simple for court-appointed work, and even for your retained work. I charge a flat fee for retained work, but you can charge hourly, and some people do. That's totally up to you. But so Securus is great. For other, here I'm going to share. Let's see. I want to bring this up. Okay. So if they're not housed in 701 San Jacinto and they're anywhere else, you use Zoom to do the visit. And so I have it down here. If they're anywhere else in Harris County, you use Zoom. And it's also very simple. What you do is you create a Zoom appointment. And in the appointment, you have to include defense visit at sheriff.hctx.net. And when you include them, also be sure to have your client's name, your client's SPIN number, and also your phone number in the event that something goes wrong and they need to call you. They will not use your phone number for anything else. But I've also visited my clients using Zoom in custody, and it's worked really great. So you open up your Zoom app, you create a new Zoom chat appointment. I always do it one day in advance. I think they ask that you schedule these at least 6 hours in advance. So for example, it'll be 5 o'clock and I'll be in my office and I'll be looking over what I kind of have to do for the next day. And if I want to see a client, visit a client, I'll just go ahead and create it right then and there for the next day. And it has never been an issue. It works really well. I highly recommend it. So 2 ways of visiting in Harris County Jail if your client's in jail, either Securus app or Zoom. Again, it's based on where they're housed, and you can find out where they're housed either through the district clerk website or the Harris County Sheriff's Office website. It will show what unit, cell block that your client is in. So that is all I have for jail visits. Moving on, communicating with prosecutors. Okay, this is a big one. And I just want to mention to you all that any CLE you go to, try and if you can just take away one thing and implement one thing a speaker or someone says that you can implement in your practice, that's really good. So I'm going to give you some practice tips about communicating with prosecutors. Number 1, email. Email is a great way to communicate because there is a written record. You always want a written record. You've heard the term CYA before. And I send emails and it's saved forever in my outbox. So that way, and I print it, or I'll save the email straight from my email program into the Dropbox of my client's file. That way I know what time and when, exactly when I email the prosecutor. During these times, during COVID, it's sometimes really, really difficult to get a hold of these prosecutors. They're not in court like they used to be every day. Before, if you sent an email to a prosecutor and you didn't get a response, you can always pop your head into their courtroom the next day and approach them and say, hey, I sent you an email. I never heard back from you. What's going on? You no longer have that luxury. The prosecutors are not in the courtrooms. They are attending court via Zoom, from their homes, from their offices, wherever. But they are not in the courtroom, so that luxury is gone. Now, what I typically do is I'll send an email if I have a question or a counteroffer that I'm making. If I don't hear back from them, I will reply back to that email and send a second email. Maybe sometimes I do it as quickly as 24 hours because I think 24 hours is enough time for someone to respond if it's an urgent matter. Or sometimes I might do it a month later and say, hey, see my email below. I never heard back from you. What's going on with this? And then if I don't hear from them again after the second email, then what I'll do is I will email their chief whoever their chief is, the chief of the court, and include the string of previous emails. Now that will usually get their attention, and if it doesn't get the prosecutor's attention, it will get the chief's attention, and you should get a response back from the chief. And then if you don't hear from the chief, which has only happened one time, then I would email their division chief. So for misdemeanors, it would be Nathan Beadle. For felonies, it depends on what court they fall in. You can always go above. So I like the work up method. I think it works great. And so that's kind of what I do. Now, if you talk to a prosecutor via telephone, if they call you or you call them and you talk to them and you discuss something about your client's case, maybe a favorable plea deal, maybe they're offering a class and dismiss, I always follow up that phone call with an email, because it memorializes the phone call and then they can't backtrack on what was talked about. So after I get off the phone with them, I will shoot them a quick email saying, hey, it was really great talking to you just now. You know, per our phone conversation, you offered this and you gave the client until this date to complete it. If I misunderstood, please email me back. If not, we will get it done. And so you always want to memorialize phone conversations, because as a baby lawyer, I couldn't tell you the number of times I've worked out something either in person, face-to-face, or over the phone, where they gave me a great offer or a dismissal offer and no one recorded it. They didn't record it on their end. Next thing you know, there's a shuffle of prosecutors and you walk into court the next time, or you deal with the next prosecutor and you say, yeah, hey, we're doing the class and dismiss. And they're like, well, I never offered you a class and dismiss. Do you have proof that there was a class and dismiss offer? And they tell you it's not in their system, and then you don't have any written record of it. So that is why it's so important to follow up any conversation via telephone or in person with an email, because even if they forget to write it on their file, on their case file, whatever, you have a written record of that, and that's how you can present evidence of what was said and what was done. So that's a big time practice tip. The third thing I'm going to mention is, we'll get into resets here in a second, but if you're resetting a case and you're just dealing directly with the court, sometimes I think it's important to shoot the prosecutor an email and kind of give them the status and kind of tell them what's going on. For example, I have a client down in Fort Bend County. She's being accused of her 5th theft. Client would love a time served on a misdemeanor. Prosecutor said, hey, I would consider it if you gave me mitigating experience. Well, with clients, we all know sometimes it takes them time in order to give you the documents you need in order for you to get your job done. And so she's made this offer from back in August, and here we are October 30th, and I'm still waiting for documents from the client, even though it's what she wants to do. And so I recently reset her case, and I just shot a quick email to the prosecutor and said, hey, just want to let you know we're still working on getting all the mitigation documents you requested together. As soon as we do, we'll turn it over. And she sent me a quick email back saying, thank you for the heads up. And it's important because she never promised that she would do this deal. She just said, send me mitigation documents and I will take them into consideration for this offer. And I think if you stay in communication with them and show them that you're doing your due diligence and your good faith, when time actually comes, they're going to be grateful. And hopefully they will honor what it is they said they would do, or whatever it is they said they might do. And so sometimes I feel it's important to just keep the prosecutor in the loop, because down in Fort Bend, they do go to court and they do lug their files to court. And at the end of court, they kind of see what files are left over and what files they did not communicate with defense attorneys with. And they are going to wonder, this person was a no-show. I didn't hear from them. Their client didn't appear. Yeah, it's likely they got reset, but what was the deal? Why did they do that? So I think it's important to keep your prosecutors up to date, especially if they're awaiting documents from your client, so that when you do actually get those things, that they don't shut you down. And you can tell them, hey, look, I was communicating with you the whole time here. So they're not blindsided. Okay, the next thing I want to talk about is communicating with the court. So with COVID, it's great. Oftentimes, you can reset your client's appearance without you having to go to court, without your client having to go to court, and just by emailing the coordinator. And it's great. And I don't even email them to ask if I can do it. I just fill out the reset and I email the coordinator and I put in the date I want and I write client's appearance waived and I just do it. And if they tell me I can't or I need to approach, it's understood. But really, I mean, just if you do their work for them, they're going to be grateful. And it's likely, and there's a less of a chance that you'll hear the word no. And we hate the word no, we want yes. And so I just, when it comes to my clients, I'll look for the week ahead. I'll see what's going on. If I have all the discovery, and this is very important, this is a good practice tip, is every time I reset, there's a line kind of in the middle of the reset where you can just type in anything you want. And every time I will change something else. So I will say, waiting on body cam. And so if we've had a 2-month reset and I'm still waiting on body cam, I will change the wording and I will insert a still in front of the waiting on body cam. So that way, if the judge ever in the future pulls wants to talk to you about the case and says, hey, what's going on with the case, and accuses you of not working up the case or dragging your feet on it, and say, look, judge, I've sent the prosecutor's email asking for the body cam, and here it is again, and I wrote on the reset that we were waiting for body cam and that we were still waiting for the body cam. So because I can type stuff up on the resets, I will. Now, be careful, I wouldn't go into anything too personal or any kind of trial strategy, obviously, any kind of communication, but things that the state has to do or the state has to turn over to you, and that's the state's responsibility, I will absolutely write that on the reset, and so that there's a record of it, and so that the state can't say, oh, judge, we timely turned everything over and yeah, we're ready for trial. No, state. It's only been 2 days since you turned over body cam, and you got to give me at least 10 days to prepare for trial. So, so yes, that's a practice tip. So communicating with the court, if you email the judge, make sure you CC the prosecutor on it. Otherwise, it'd be considered ex parte communication. But when it comes to dealing with the coordinator, there is no ex parte with the coordinator. You just send them the reset and put the date and time you want on there. Well, not the time, you should know what the docket times are, and just put whatever date on there. And if they email you back and say that doesn't work, then that doesn't work. Or if they email you back and say you need to approach, then you need to approach. But you can really move your day along if you can reset these cases from the comfort of your own home the day before. So I'll usually the night before, I'll look at what I have the next day and I'll fire off as many resets as I can. And that way I don't have to worry about it the morning of. So, and in the email subject line, I always include the cause number, the name of my client, and the fact that it is a reset attached. So just a little tip, it's worked great. Some coordinators will respond back with a received, some will not respond back with anything, and they'll just enter your reset, and it's wonderful. So the less time you're in court or waiting on Zoom, waiting to approach, the more time you have to work on your client's cases, and that's what we want. We want to maximize the time y'all have to work on your cases. Okay, so that is what I have with communicating with the court. As far as docket and pretrial appearances, do everything you can to waive your client's appearance. A lot of courts, it's automatic. Most county criminal courts now in Harris County, it's just you ask for it and it's waived. There's very few judges give you pushback on your clients having to appear. If they are requiring your client to appear, the fallback should be, judge or coordinator, can they appear via Zoom? And so you want to save your client the trip downtown, the parking, the hassle of that long line to get in the building, the possibility of catching COVID from someone in the line, the elevators. There's only a limit of 4 per elevator. And so you want to make this, at least I do, I go out of my way to make this horrible, miserable process that our clients have to go through as painless and as easy for them as possible. And so if you can't get their appearance waived, which really shouldn't be a problem in most courts, see if they can appear via Zoom. And if they need to appear, if the judge says no, they need to appear, then they need to appear. I mean, sometimes there's just no way around it. But definitely, my advice is exhaust every step until they have to appear. Don't just automatically assume your client has to be in court. Don't tell your client they have to be in court if they don't have to. In fact, some courts in their emails are saying, please tell your client not to appear. And you don't want to be that lawyer who did not tell their client not to appear when you were told to tell your client that. That just doesn't look good on you or your client. Your client's going to get frustrated with you, and it just saves a whole lot of trouble and heartache. So do everything you can to waive your appearance, and let's keep this train of waiving appearances going, because ultimately that's the goal. In civil cases, the client never has to appear for any of the docket or pretrial settings. So we want to make that the norm in the criminal cases as well. So it's our job to ask for waivers. It's our job to ask, hey, even if they're not waived, can they appear via Zoom? So do it, and do it in every single one of your cases. And if we do it enough times, I think judges will change their position if they're not already on board. So that is pretrial appearances via Zoom. Okay, the next are hearings via Zoom. I did a hearing via Zoom. It was a case down in Fort. I've actually done a couple of them. And really, they're not any different than hearings via in person, but I will just, the thing I want to talk about the hearings in Zoom is practice using your Zoom, practice using your screen share, make sure you have all of your documents or files that you plan on presenting in one file in your folder, so that's easy to get to. Judges understand, and we're all new to it, and no one's expected to be a pro at using Zoom, but use a little practice, because you don't want to waste the court's time, 5 minutes of trying to open up a file and sharing it on your screen, or trying to play some audio or video. So that's really the main thing, is practice. Judges are going to be very lenient with you, and we want to be able to have these Zoom hearings, pretrial hearings, because sometimes they're advantageous to us. And so the more we show that it works, the more they will allow us to have it. Now, sometimes it's more advantageous to us to have it in person, but we definitely want to have the option, especially if the state says that their witness is over 100 miles away and they're not able to appear, and you really need to get something out of them on the record. And it's all about protecting the record. So if that's the goal, we want to keep these Zoom hearings going. Make sure you ask for a court reporter. The one I had was audio recorded, and the court reporter, I just emailed them after the hearing and I said, hey, will you please let me know how much it costs for the transcript of the hearing? So, or sometimes the court reporter will be there transcribing. It really doesn't matter, but make sure any hearings, whether it's Zoom or in person, practice tip, always ask for a court reporter, always ask for it to be on record. Or if the judge is making some asinine ruling or telling you that you can't do something, just be like, Judge, can we get a court reporter out here and get that on the record? That's a great way of getting what you want, or it's a great way of not allowing the judge to push you or your client around. So that's my practice tip on the Zoom hearings. Now, live hearings, I had one yesterday, actually. I was in Court 7, County Criminal Court at Law 7 here in Harris County. And the judge there, Judge Wright, he wants people there in person. And he doesn't really care about COVID. And he doesn't, I mean, he made the state sit at their table with their masks on. I sat at the defense table with my mask on. The witness came and sat kind of near the front of the bench, but they had all the space in the world with their mask on. Everyone was in the courtroom, and we conducted a live hearing. And so some judges want live hearings, and I'm not. It's up to everyone's comfort level. I think you shouldn't be forced to do it live. Even Judge Wright, if you give him a good enough medical reason or condition, he won't make you come down. But that's his preference, and every judge has their own preference. Some judges don't want you in the courtroom at all. Heck, some judges, like Judge Fleischer in Court 5, I don't think he's been down to the courthouse since March 14th, and he wants everything via Zoom. And so you have to get to know your judge and what they like. And it's possible by doing a hearing in person over Zoom that the judge will give you a more favorable result. I don't know, but that's something that you need to talk to about your client and consider. And so that would be my practice tip as far as having in-person hearings. If it's more beneficial to your client to do it in person, then do it in person. If you think that will help or give you a more favorable ruling, so long as you're comfortable with it. Okay. Moving along, number 7, grand jury packets. Grand jury packets, I cannot stress enough to everyone on here how important it is to do grand jury packets on all your felony cases. I recently had lunch with the foreman of a grand jury who served for 3 or 4 months in Harris County. And he told me in less than 1% of the cases they saw was there actually a grand jury packet. And they actually get really excited when there's a grand jury packet, because for 99% of cases, they don't get to hear the defense side of the story. And so whatever the prosecutor says, it goes, and they just indict, because there's no other side to the story, even though we all know there's at least 2 sides to every story. So, Rusty Hardin charges $50,000 to put together a grand jury packet. He does so because they work, and he knows he can get cases, he can win cases in grand jury. And I recently had a client who went to him and then came and hired me because, he wasn't going to pay $50,000 just for a grand jury packet. But they work, and we are able to tell the story. Now, during COVID, the twist is prosecutors, they don't want the 13 hard copies like they used to pre-COVID. So what they are asking for is a PDF. And so what I suggest is put together your hard copy packet and then scan it all in as one PDF and name that grand jury packet of so-and-so. And you can email that to them. Now, there are certain advantages that you can use because these grand jury packets are PDF or in electronic form. I haven't been able to figure it out, but I know some lawyers are including audio links, video links in there. And these are things to get you to think about more persuasive ways of telling your client's story. Because the way we win cases, the way we win people is by effective storytelling. And so if you can include an audio clip, or if you can include a video clip, whether it's from your client or whether it's body cam or dash cam or anything you think that might help your case, do it. Because up until now, we used to never be able to include kind of electronic files and embed audio or video in these packets. But we can now because they are in PDF format. And so if you're smarter than me and you can figure out a way to link it up or embed it, do it. Take advantage of this stuff because it works. And so as far as grand jury packets, do them on your felony cases. Put your best foot forward. And I just, I cannot stress enough how well they work. Sometimes in the past, I've turned in a grand jury packet to a prosecutor, and after the prosecutor went through it, the prosecutor said, I'm going to dismiss this case because they were convinced by the evidence in the grand jury packet. They didn't even have to take it to the grand jury packet. So write a really good letter in there on behalf of your client, put a lot of good evidence in there, include the offense report, include the law, and do them because they work. And if anyone would like a sample grand jury packet, I'm happy to email them one to you. I'll put my email address at in the chat at the end. And if you'd like to see what a good one looks like, or one that's worked for me in the past, I'm happy to send you that. So that's what I have as far as grand jury packets. Now let's get to bench trials. So bench trials, there was typically to do a bench trial, you get your client to waive the jury. Now, up until just recently, the state would also have to waive their right to a jury trial. Until this past Wednesday, when a case came out, and the case is included in the materials. It's out of the 14th Court of Appeals, and it is titled In Re, the State of Texas, Ex Rel Kim Og Relator. And so what this case talks about is under current coronavirus conditions, we don't need the state to waive their right to a jury trial. Personally, I don't think the state has a right to a jury trial. I think only the accused has a right to a jury trial under the Sixth Amendment of the Constitution, as well as the Texas Constitution. But I always argue the state does not have a right to a jury. So a lot of times it falls on deaf ears, but this case that just came out on Wednesday that I've included in the materials says that you don't need to get the state to waive their right to a jury trial. So if you're in a county court and you have a favorable judge, such as Judge Bynum in Court 8, or Judge Genesis in Court 12, or Judge Tanya Jones in Court 15, or Judge Jordan, or it's now Judge Fields covering for Judge Jordan in Court 16, and you want to try the case to a judge because that's better for you, do it, ask for it. The state can't object. And this case, all you have to do is show the court this case, and they're going to agree with you, and they're going to set it for a bench trial. So if there is something favorable and it's more of a legal related issue than a factual issue, I recommend going to the judges for bench trials. Another thing you might want to do is file a speedy trial motion. And I've also included one that I filed in one of my cases that I was asking for a bench trial. This was back in April. We didn't have any jury trials, and we didn't know when jury trials were going to resume. I had a client. He was in custody because of a parole hold, and the offer was time served, but I didn't want to plea him out because I didn't know how that would affect his parole. And so I kept pushing for a bench trial, I filed my speedy trial motion, and the judge said, yep, we're going to have a bench trial. We don't have jury trials. Client has a right to dispose of their case in a timely manner. And so he granted it. And of course, 5 days before the actual trial, the state dismissed the case. Even though the chief of the misdemeanor court promised that he would come down and try it himself. I guess he had a change of heart. So sometimes you do want to push the state to a trial, and if that's the case, you want to do a bench trial. Now, when it comes to jury trials, I think, and this is the 9th thing on my top 10 list. When it comes to jury trials, I think now is a very, very, very bad time for the defense to be trying cases. I am set for one on Friday, a week from today. It's a DWI first. It's out of Judge Wright's court in Court 7, and he is forcing us to go to trial. And I think, and I don't want to go to trial, and even the state doesn't really want to go to trial, but it is a very, very, very bad time for the accused to go to trial because the people who are showing up for jury duty, and the people that typically are showing up for jury duty are right-wing authoritarian type, and right-wing authoritarian people who think that COVID is a fake virus, or all of this is fake news, or it's blown out of proportion. They are the types of people who listen to the government prosecutor. That's who they're going to follow. They're going to listen to the police. They're going to listen to the prosecutors. And so it's not a fair cross-section of the community that is showing up, because people who are truly concerned about their health and the people who are truly concerned about COVID and its implications and viruses are the ones who are going to hold the state to the beyond a reasonable doubt burden. Those are the ones that are going to hold the state's feet to the fire. And we don't have those people coming in, or if we do, they're a lot less than what we're used to. And so my advice is file continuances, written, sworn continuances in all of your cases where a judge is forcing you to go to trial and where you don't have to. And I've included a beautiful motion. It's about a 29-page motion, I believe, written by people a lot smarter than me that are members of TCDLA, Texas Criminal Defense Lawyers Association, and as well as a cheat sheet for you to argue the things on the record when it comes to your continuances. So I'm telling you, now is not a good time to try cases. I really don't know when a good time to try cases will be. I think people have hope in a vaccine, but I think even when a vaccine comes out, there's going to be people hesitant of getting a vaccine done. And even with a vaccine done, it still is not going to eliminate the spread of COVID. And so I would urge you, if your client is on bond and they are enjoying their freedom, try and push back these jury trials as long as possible. My goal is, until we can do a jury selection at 1201 Franklin, I don't want to try a case. Unfortunately, I'm going to have to next Friday. I've filed my motion for continuances, and he's just denying them. But preserve your record. Preserve your record. We don't know how these cases are going to turn out on appeal. And if you don't complain about it in the trial court, you might not get a chance to complain about it later on in the appellate court. So even if you know your judge is going to shut you down, file the sworn motion anyway. Go on the record. Say, Judge, I want to be heard for purposes of the record, and I want to make my continuance known. So really important to do that in all your trial cases. And I'm telling you, you want to, so long as your client is enjoying their freedom and they're okay with staying on bond, I highly recommend not trying any jury trials until we can conduct them safely at 1201 Franklin. Okay, and that brings us to our last point, which are pleas and sentences. Every court is a little different as far as pleas go and plea paperwork. Some of them you can generate using the kiosk section of the district clerk's website. Some prosecutors will email you the plea paperwork. You can print it out, sign it, have your client sign it either in your office, or maybe you can send it to them. They can print it out, sign it, and scan it back to you, or mail it back to you and submit it that way. So there's a lot of different ways pleas can be done without having to go into court. I was in court 15 today, and I saw a couple lawyers do their pleas via Zoom. One was, the client was in custody and they brought him out of the jail and they did the plea, and the other one, the client was not in custody, but the lawyer was on Zoom and did the plea that way. So the goal of all this is, let's keep this Zoom option going. You may not like it, but it's super convenient, especially if you have to be in 2 or 3 different counties at the same time, and none of the counties are willing to budge. And so my advice to you is use the Zoom whenever possible over going to in person, and show these judges that the Zoom works, and show these judges that anything we can do in person, we can also do via Zoom, so that they keep the option going even when COVID is over, because you never know when you're going to be in a bind and you're going to have to be in two places at the same time, where you can be in one person, be in person at one place and be on Zoom in a totally different place at the same time. So my advice is, let's make it work. Let's be patient to each other. Let's be kind to each other. It's not ideal conditions, but we all have to play our part, and everyone's going through this COVID deal at the same time. So that's that. The last little thing I wanted to touch upon is our sentences, and a lot of judges are doing house arrest in lieu of jail time. And I would argue that the key to argue is, look, judge, my client may have done this, this, and this, and he should be punished for it, but he shouldn't be sentenced to death because he stole a pack of bubble gum and he has 2 prior thefts on his record. He shouldn't, especially if they're elder or a little bit older, or if they're obese, or if they have some sort of underlying condition. I would make that very known, and judges are being very considerate and are coming up with a lot of different ways of doing jail time. One is just promise you're going to stay home for pick 5 days and promise you're going to be home for 5 days, and just tell your client to do it. It's a lot better than going to jail. So you can get really, really, really creative as far as sentences go. If they have your client and your client has to plead to jail time, they don't want probation, and they just want to sit it out, sit their time and be done with it. Think of ways to keep your client out of jail, and that is one way of doing it. So with that, about 15 minutes left for Q&A.
Okay, thank you so much, Arman. We have some questions that are popping up in the chat box. Again, for all of our attendees, if you could put your questions in the chat box, we will try our best to address each one of them. Okay, so the first question comes from Regina Turner, and she asks, how do you suggest to get to know a judge that you have never presented before? And she says that she would love an email to her email address, and she put it in the chat.
Okay, I'm not seeing the chat questions. I don't know if there's a way of doing that, but
if you scroll down the bottom of your screen, you'll see the chat box. Mm-hmm. Just open it up.
Oh, Regina Turner. Yes. Okay, there, I see it. Okay, great. Yes. So how do you get to know a judge during COVID? So pop in during their docket via Zoom. A great way. So I have included in this, in a helpful links here, I'm going to share my screen again real quick. I have included this document right here. And so for district courts, you can click this link and it will have a link to all of the courts' Zoom link, as well as their policies and procedures and kind of what the judges like and don't like. And the second link here, that's for all the county criminal courts, misdemeanor courts. You'll see the Zoom link, as well as a YouTube link that they broadcast on. So if you want to observe, it's a great way to observe. But what I would do is, if you're a new lawyer or you want to introduce yourself to a judge, if they're not in court and you don't want to go to court, I would just kind of hang around till the end of their docket. And once they're done with their business, say, hey, judge, my name is so-and-so, and I was wondering if you had a minute to chat. I'm a new lawyer, or I haven't practiced before your court, and I might in the future, and I just wanted to introduce myself. And judges are really like that. And that's what I do when I go to counties where I've never been before. I recently got retained on a DWI in Washington County, which is Brenham. And I went to the first court setting, and the judge was in the back, and I just said, hey, judge, would you mind if I visit with you? And that's, I really, really recommend that. Get to know your judges, get to talk to them, get to know what they're like, what they're not like. They they're a lot less likely to screw you and your client over if they know you. Not saying it's not going to happen. I consider Judge Wright a personal friend of mine in Court 7, and he's still forcing me to go to trial next Friday. So simply because you know them, or you might even be friends with them, don't ever expect any favorable results. One practice tip that I tell all my mentees and young lawyers is always be the most prepared and honest person in the courtroom. Always, always, always. And I think honesty is even more important than being prepared, but make it your goal, no matter what courtroom you walk into, to be the most honest and most prepared person in that courtroom. That's how you will win. That's how you'll win your motions. That's how you'll win your cases. That's how you will get favorable results for your clients. So, yep, that's my tip.
Thank you for that. The next question came from Anthony Franklin. I believe Whitney answered his question, but his question was, where can we find the packet of information that the speaker is referencing? So I know we're going to have a follow-up email after this CLE with the attendees. So if you could provide that, if you haven't done already, to Gloria, and we'll get it out.
Yes, I emailed the zip file to Gloria 30 minutes before we started, so she should have it, and hopefully she can email it to everyone. Yep.
Perfect. We'll send that out. Are there any other questions from our attendees before we wrap up? Whitney, you're muted. Okay, no questions. Oh, okay. Okay. Go ahead and wrap up. You can go ahead and wrap up, and then I've got a few more housekeeping.
Sure. So if anyone wants to email me for a grand jury packet or any other questions that you might not want to ask, I just put my email address in the chat, and I'm even going to put my personal cell phone number in here, and y'all can text me, call me anytime. I'm happy to talk to any lawyers, old or young. I'm sure a lot of you are kind of younger, newer, just past the bar. I was in your shoes not that long ago, and I've had some great mentors, Rocket Rosen, Mark Bennett, Mark Thiessen, Troy McKinney, and a great way to get better is by learning from people that have come before you and that have gotten good results. And so happy to share anything and everything that I know to help your clients, because if you can get the prosecutor to say yes to you, then they'll say yes to me. And the goal is to get them into yes mode. And so the better results y'all get, the better results I'll get, and vice versa. And so we need to keep that in mind when practicing criminal defense and helping our clients, because that's what it's all about.
Sure. Thank you for that. I recall several of those names. We've had them as presenters in the past for our Indigent Defense Series CLE. By the way, before I launch into closing statements, I did want to say that we are having our Commissioner Rodney Ellis and the Honorable Craig Washington Indigent Defense Series. That will be coming up next year in February. So just keep your eyes peeled for that. And I will begin my wrap up. My name is Zara Buck Whitfield. I am an associate director at the Earl Carl Institute, along with Whitney. Thanks again for your participation in today's criminal law CLE. We will be emailing a CLE certification form to you following this webinar. Please complete it, sign it, and return it as soon as possible so we can submit it to the State Bar on your behalf. The credit hours are 1 hour MCLE for today's webinar and a half hour in ethics. Our next CLE, as you can see on the screen, will be November 6th at 4 p.m. And the topic is the impact of COVID on child visitation. It will be a webinar, and we will also send you the Zoom link for that as well. If you want more information or you need to follow up, say your clients are indigent and are in need of free legal services that Whitney mentioned at the beginning of the webinar, we can be reached at 713-313-1139 or at 713-313-1072. And you can also go to the Earl Carl Institute's website, and the website is www.earlcarlinstitute.org. Let's see, I think I have something else just popped up in the chat. Okay, so you're getting a lot of great feedback here, Arman, on your presentation. Everyone thoroughly enjoyed it.
Good, great.
And go ahead.
I said I'm glad. Thank you so much for having me. It's really a pleasure to present, and Texas Southern, I've spoken there before, so really, really appreciate you guys. Keep up the good work.
Wonderful. Hopefully we can have you on as a panelist in our Indigent Defense series. And with that, that concludes our webinar for today. Again, be on the lookout for an email that should be coming your way shortly. Thank you. Bye-bye.